Half a day. The Committee on Health, Land, Justice, and Culture is now called to order. Today's May 16, 2022. The time is 3:07 p.m. I'm sorry, 4:07 p.m. In compliance with the Open Government Law, notices for this public hearing were published in the Guam Daily Post on Monday, May 9, and again on Friday, May 13, 2022, and posted to the Government of Guam Public Notice Portal. Notices were also disseminated via email to all senators and all main media broadcasting outlets. Individuals testifying today shall first be recognized by the chair before speaking, and please begin by stating your name for record-keeping purposes. We have only one agenda item, and that is Bill number 301-36 COR, introduced by Senator San Agustin, who will introduce the bill shortly. And I'd like to recognize my colleagues who are here with us. Of course, the bill sponsor, Senator Joe San Agustin, Senator Terlaje, and Senator Anthony Ada. Thank you, colleagues, for being here today. All right, so we'll now hear from the sponsor to introduce the bill, including the title, please.
Thank you, Madam Speaker. Good afternoon and half a day to our people and my colleagues. Bill number 301-36 LS as introduced by myself, is an act to approve the land lease agreement as lender's condition to fund the construction of a 198 megawatt power plant and BESS facilities located on lots number 5010-1 new-1 and 5010-1 new-R1. DEDEDO and a related reserve facility located on lot number 261-2 PITI Guam, and to authorize the use of those properties for such purposes. We have all heard of the work our only electric power producing authority, GPA, has been doing to ensure the best, adequate, and reliable energy is provided for all the consumers on Guam for home and businesses. This includes the work to fulfill the requirements of a consent decree filed on April 20, 2020, requiring GPA to construct and operate a new generation utilizing ultra-low sulfur diesel to resolve violations of U.S. environmental laws from the operations of the Cabras and PITI power plants. After a very vigorous public competitive bidding process in accordance with Guam procurement law and approval by the CCU and PUC, GPA and Guam Ukudu Power LLC entered into an energy conservation agreement and land lease agreement under the authority of Section 8104, Title 12, Guam Code annotated. In 2010, in order to create the balanced playing field, Public Law 32-40 was enacted requiring legislative approval for exceptional term leases, defining the lease length associated with the cost of the project. Bill 301 addresses the need to fulfill this provision and authorize a long-term lease in PD and Ukudu to ensure GPA and GUP's contract can be properly executed to cover the terms of the agreement in the use of the land for the building of the new power plants. This bill will help support the foundation that GPA has been working diligently on to ensure the best practices in power production while fulfilling the requirements of environmental stewardship with Guam and U.S. laws. Our support for GPA will transcend to all our people with rates that are manageable while providing the reliable power they have worked so hard to maintain over these years. Madam Chair, I appreciate your commitment to hearing this bill at your earliest opportunity, and I look forward to the discussion and testimonies from our stakeholders today. Madam Speaker.
Senator San Agustin. I'd also like to recognize the presence of Senator Joanne Brown. All right, we'll begin with receiving testimony on the bill. We'll begin with Guam Power Authority, of course, the General Manager, Mr. John Benavente.
Thank you, and of a day, Madam Speaker Terlaje. First of all, I'd like to thank you for scheduling the public hearing on this very important bill to us. Senator San Agustin, thank you for introducing the bill for us, and Senator Ada, Senator Brown, and Senator Terlaje, thank you very much for your interest in attending today's public hearing. I am John Benavente, General Manager of the Guam Power Authority. Thank you for the opportunity to provide testimony. The Guam Power Authority supports Bill 301 and respectfully request the legislature Guahan to do the same. GPA's major projects, such as those designed to expand the island's generation capacity, are best accomplished through public-private partnerships. This was the case in 1996 when GPA was allowed to enter into IPPs to build, operate, transfer the PITI 7 combustion turbine with Therese and the PITI units 8 and 9 with MEC. All units were constructed on land owned by GPA. Upon completion of their contract terms in 2017 and 2019 respectively, the facilities and the land were transferred to GPA at no cost. In 2009, the 30th Guam legislature expanded GPA's authority, allowing the public utility to enter into long-term IPPs not to exceed 30 years for renewable energy contracts, purchase power agreements, refurbish, operate, maintain, and build, operate, transfer contracts that cost $30 million or more through Bill 175-30 COR, now Public Law 30-66, and codified in Section 8104 of Title 12 Guam Code Annotated. It was under this authority that GPA entered a 30-year Build, Operate, Transfer contract with Guam Ukudu Power LLC concerning the 198-megawatt baseload power plant to be constructed on GPA-owned parcels in DEDEDO and PITI. The primary 198-megawatt plant will be constructed on Lot 5010-1 NEW-NEW-1 in Ukudu, DEDEDO. The 41-megawatt reserve units are proposed to be located on Lot 261-2 in Cabas, PITI. The Energy Conversion Agreement, ECA or contract, specifies the terms of agreement and includes the land lease agreement. The land lease agreement establishes the legal authority for GUP to construct and operate a new baseload power plant and reserve units on GPA-owned land parcels at a nominal cost of $100 per year. We have worked with the Attorney General's Office and the Office of the Governor to ensure prompt execution of the lease should the legislature approve our request. They have requested certain additions to the lease draft that track current law. These are minor changes or clarifications in nature that do not substantially change the draft lease as attached at 2 Bill 301-36. GPA has agreed to the changes and is working with the parties to make these modifications to the draft lease. The proposed lease modification is attached to my written. My apologies. My apologies. The proposed lease modifications is attached to my written testimony as submitted this afternoon. Section 5127, Chapter 5, Title 5 of Guam Code Annotated, formerly Bill 69-32 COR, and now Public Law 32-40, requires legislative approval for exceptional term leases. Former senators at the 2013 legislative public hearing explained the purpose of Bill 69-32 COR to create a level playing field for bidders by clearly defining the leased land. Furthermore, leased land may be based on the associated project bid cost or investment. For instance, large construction project valued at $40 or $50 million would need a long-term lease. GP agrees that the terms of all public-private land leases should be clear to prospective bidders prior to the issuance of any contract or award. In any case, the Ukudu Power Plant ECA, the maximum contract term is 30 years. The resulting land lease agreement term mirrors the ECA, which is Energy Conversion Agreement. The operating term and transfer dates were key terms of the bid packets and the resulting award. There was no confusion or ambiguity. The notice and safeguards intended by Public Law 32-40 are fulfilled by the IPP requirements as specified by Public Law 30-66. Guam Ukudu LLC, the entity contracted to build, operate, transfer the new baseload Ukudu power plant, is finalizing the project financing. GUP's institutional lenders have noted that this legal conflict and request that conflict be resolved through legislative action. For the foregoing reason, I respectfully request your support of Bill 301-66. Against Jesus Masi for the opportunity to provide testimony, and I'm available to address any questions you may have, and also with me Mr. Graham Bota. Thank you.
Thank you, Mr. Benavente. Mr. Bota, would you also like to testify on behalf of GPA?
Thank you, Madam Speaker, but I'm just here to answer any questions that either you or any of the senators may have on the bill.
All right, if you don't mind, then just state your name and title for the record.
Yes, Graham Botha, GPA General Counsel.
Thank you. All right, so now I think on behalf of the Guam Public Utilities Commission, Attorney Fred Harecki, Chief Administrative Law Judge.
All right. Thank you, Speaker Terlaje, Senator San Agustin, Senator Ada, Senator Brown, and Senator Titagui. My name is Fred Harecki. I'm the Chief Administrative Law Judge for the Guam Public Utilities Commission, and I'm presenting this testimony on behalf of the Chairman, Jeffrey Johnson. The Public Utilities Commission appreciates the opportunity to comment on proposed Bill number 301-36. The PUC strongly supports this bill. Its passage is critical to the future of Guam's island-wide power system. The bill would authorize GPA to enter into a lease with Guam Ukudu Power for up to 30 years for certain lots in DEDEDO, Guam, and PITI, Guam. The leased lots are those upon which Korean Electric Power Company, KEPCO, has contracted with GPA to build a 198 megawatt diesel dual-fired power plant and a related battery energy storage system, and a 41 megawatt high-speed diesel reserve facility in PITI. This is a project that the PUC, CCU, and GPA have been working on for many years to bring to fruition. It's believed that these essential facilities will be of great assistance to maintaining a reliable power system for the people of Guam. In 2015, the PUC approved the construction and commissioning of the new Ukudu power plant. In 2018, the PUC approved the energy conversion agreement between GPA and KEPCO for the construction and operation of the plant. In 2021, the PUC approved the amendment to the energy conversion agreement, which allows the construction of a 41 megawatt diesel engine reserve facility at the Cabras site. Dr. Johnson believes the problem here is that KEPCO is not really willing to proceed with the construction of the power plant unless there is a lease agreement authorizing it to use the sites of the power facilities in DEDEDO and PITI. It would really be quite disastrous if the legislature did not approve the proposed land lease. In that event, KEPCO might well back out of the entire ECA agreement and refuse to proceed ahead. Inaction or failure here by the legislature to approve the lease does not seem to be possible in these circumstances, and if the lease is not approved, that could really undo or scuttle the years of efforts that everyone has put into making this power plant project a success. As indicated in Section 1 of the bill, legislative approval of the lease is the final step in a lengthy and publicly intensive process. It would be hard to go over all the public hearings that were held by GPA, the PUC about the new power plant. There was tremendous amount of public input, and in the end, all these parties have approved the building of the new power plant and deemed it necessary and essential to proceed ahead with that power plant. Furthermore, under the consent decree that was entered into by GPA and the US EPA, the District Court of Guam ordered that the new power plant project be completed by April 2024. Failure by the legislature to approve the lease could render GPA unable to comply with the dictates of the consent decree and subject GPA and the ratepayers of Guam to substantial amounts of imposed damages for a failure to comply with the consent decree. So in other words, GPA doesn't really have any choice in this matter. They have to complete the plant by April 2024. There would also be other far-reaching and severe detriments if the legislature did not approve the lease. The ratepayers would be denied the benefits of the improvement of the power system, which will result from the construction and operation of these necessary and essential power facilities. And I think, unfortunately, you've seen lately what happens when our power system is not strong enough. Due to some plant issues and some of our bigger plants going down, there's been some small amount of load shedding. If this new power plant is not built, certainly you could expect more and more of that type of problem to develop over the years. There are other benefits that will result from the new power plant. It will reduce substantially sulfur and other harmful pollutants, thus providing a cleaner environment for Guam. GPA has repeatedly indicated that without the new power plant, it will be impossible for it to meet the 100% renewable energy goal by 2040 and to continue to add renewable energy to the island-wide power system. GPA GM John Benavente has also stated that the construction and establishment of the new power plants will, in the long run, reduce fuel bills of ratepayers and fuel recovery charges under the Levelized Energy Adjustment Clause. And this morning I heard a comment on the radio by CCU member Simon Sanchez explaining this. Right now, GPA burns about 2.7 million barrels of fuel per year, but it's anticipated by Mr. Benavente then when the new power plant becomes operational, that could be reduced down to 1.4 million barrels. So although the ultra-low sulfur oil is somewhat more expensive, it will definitely save money on the fuel expense when the new power plant is built. So right now, you know that the LEAC charge to ratepayers is about 21 cents per kilowatt hour. It's been estimated that after the new power plant is built, that the LEAC charge could go down to somewhere between 11 and 13 cents per kilowatt hour. So definitely a lot of potential advantages will result from the new plant. Therefore, the legislature should approve the lease, which will help to enable GPA to reduce fuel charges to the ratepayers of Guam. Approval is necessary and essential for the future of the island-wide power system and to avoid high fuel charges. Without the construction, as I mentioned before for Dr. Johnson, the existing power system will continue to degrade and falter and likely will be unable to continue to supply the public with reliable and efficient power. On behalf of the PUC, I respectfully request that the senators of the committee and the Guam legislature support passage of Bill number 30136. And the testimony is signed by Jeffrey Johnson, Chairman, Guam Public Utilities Commission. Thank you.
Thank you, Attorney Harecki. All right. There being no one else to testify at this point, I'm going to ask a couple questions, if you don't mind. All right, so the bill does a couple things. It authorizes a lease up to 30 years, which is beyond the 5-year statutory limit. That's one. It authorizes these particular leases that are attached, except Mr. Benavente, you said that there are some changes to the leases that are being proposed by the AG and the governor. Would we be able, are you going to submit an amended exhibits?
Madam Speaker,
Attorney Bota, please.
Yes, I'm sorry,
Make
Madam
sure your
Speaker,
microphone's on.
Sorry, Madam Speaker. The modifications that they put in are attached to Mr. Benavente's testimony, but if need be, we could show the changes as needed on the exhibit. It's only on the exhibit to the lease agreements that the proposed changes from both the Attorney General's office and the Governor's Council were requested.
That's right. So we see the proposed changes to the exhibits, but we are, by the bill, approving the exhibits. So will we be receiving new exhibits?
We can submit another exhibit
Okay.
with the changes as highlighted
All right.
here.
Highlighted in your testimony. Okay. The first change is pretty much looks historical to me. It's describing the history of what has transpired, and that the public law requiring air quality and emissions testing and control at PITI is going to occur. So it says that we are going to be adding to the lease recitals that GPA will install air monitoring devices at the Jose Rios Middle School and the Port Authority of Guam no later than 90 days prior to the commercial operation date of the 41 megawatt diesel units, subject to compliance requirements of the Guam EPA. And this is to conform with the Public Law 3691, which was passed by the Guam legislature earlier, to bypass that original statute restricting use at PD. Right?
Yes, that's correct, Madam Speaker.
Okay.
That was from the Governor's Council, and obviously for on the signing statement for Public Law 3691, that was important to the Governor and her council.
Yes.
So the only thing that's really additional, the other, I mean, in the recital that's already in the law, but they just wanted to clarify that there was something in the recital
I
as
think
to
that's a great idea. So we're holding the contractors to that law, and we're saying it's part of their contract that they will comply with those emission requirements. Okay, and then the other one is just adding in something in our procurement law that should be there. It's prohibition against contractors employing convicted sex offenders. And then the third one is adding, clarifying that jurisdiction, if there's a dispute under these contracts, are going to, or these leases, is going to be with the courts of Guam, not limited to only the District Court of Guam, but to any of the courts of Guam. And so these are good changes in my book, as long as we get a new exhibit. So because we are approving the exhibit, and if there are any other changes to that exhibit, please highlight those or let me know exactly what those are. That would help us to expedite. Okay, and then the other thing that the bill does, besides allowing for a 30-year lease of these properties, is on page 4 of the bill, lines 21 through 26, it says, and that the construction and operation of a natural gas ultra-low sulfur diesel dual-fired power electric facility and a related battery energy storage system on these lots, and an ultra-low sulfur high-speed diesel reserve facility on the PD lot, is, as a conditional use of said properties, hereby authorized, approved, and permitted. I had discussed this with you, of course, earlier. So we are also, by this bill, approving a conditional use of the properties for these purposes, which I think were anticipated of course, by earlier authorizations. They were also anticipated through Public Law 3691, which was passed for the PITI property to allow it to be used for this ultra-low sulfur diesel fuel plant. But my question is, if we're approving the use, it doesn't have to go anymore through the Guam Land Use Commission, it looks like to me, if we are approving it here by statute or by law. But what about this part? Hereby authorized, approved, and permitted. What about the permits? I don't want by this bill to be bypassing any permitting procedures, because we relied on that. I think your representation that all the permitting, you would still have to go through all those permitting with the, for example, Guam EPA, US EPA, and all of that. So I don't want to shortcut any of that. I want GPA to go through all those permitting process. Is the word permitted necessary in this line?
Madam Speaker, I think certainly, as we discussed earlier, there's no certainly intention to bypass any of that. We have already applied for the draft air permit for the Ukadu location, and working on the one for the PD location. And I think there's no intent to do that, certainly. It's just the conditional use. I think that has always been a question, because there is nothing within the zoning law specifically for a power plant. And so, it's unfortunate that there isn't. And so we certainly would like the conditional use part to stay in it. But I think as to the permit one, that would not be necessary, because we have obtained already a phase 1 construction permit for them to start some basic construction. So the permit part certainly wouldn't be necessary.
Right. I think you intend to say authorized, approved, and allowed, but
Yeah.
just my hang-up is that word permit, right? I don't want to say we are permitting by this bill at all. So what about, can you just discuss that for a little bit? So we're allowing a conditional use of this property. What is the zone of these properties?
So currently the PD property is unzoned, because that was given by deed from the U.S. Navy, to Guam Power Authority. And obviously even the Navy operated both those lots. 257, 261 is a power plant, the PD power plant originally from the 1950s. But there's never been a zoning for any of the property from the Navy that was given to Guam Power Authority. But it does say on the deed that it is only for power plant purposes, right? And then the second lot is for fuel tanks, and those are currently located on the lot. And as to the Ukadu DEDEDO lot, those lots are currently zoned M1 when we purchased the property and had that done. But once again, even for that, a power plant is not a permitted use under M1 or M2 for that matter. There is no permitting for that. So I think the intention was that the conditional use would allow for a power plant on both of those lots.
Okay, so you intend for this conditional use language at the end of the sentence to apply to both A and B?
That's correct.
Okay. And then normally when the process goes through the Guam Land Use Commission to obtain conditional use approval, they notify the municipalities, and they get municipal planning council agreement by resolution. Do we have that in this situation?
Madam Speaker, as a matter of fact, for both lots, we do. We went to the Municipal Planning Council in PITI before we did Bill 213, now Public Law 3691. So we went and did that, and the Municipal Planning Council did have no objection for waiving the 1,500 feet requirement. And also, as well, there was a height variant that was done by Guam Ukadu Power for the Ukadu lot for the stack height. So it did already go through that same Municipal Planning Council and Department of Land Management process for that lot as well.
For variance for the height?
For the height variance.
Right. And would this language then in the bill allow for variance of the height requirements in PITI?
Well, it would be as a conditional use for the power plant. I'm not sure that there would be much of a need for a height variance because these are the smaller diesel units that don't require the same height variance as for the combined cycle units in Ukadu.
Okay. All right, and just for the record, so I did contact the mayors of DEDEDO and PITI and asked them if they had any objection to this conditional use for these purposes and whether their MPCs had resolutions in that regard. And so I think they will be submitting additional resolutions in support of these. We'll see, and I'll make sure that that's included as well in the record, as well as the ones in the past that they had submitted. All right. That's the zoning and the permitting. The fiscal note on the bill says the proposed legislation has no direct fiscal impact on the general fund as confirmed by GPA. It may have an impact on the revenues and expenditures of GPA, which is autonomous, and that GPA stated that the passage of this legislation is crucial to meet the requirements of the April 2020 consent decree as it pertains to the commissioning of the new Ukadu power plant in DEDEDO and reserve facility in PITI. Do you think approval of this lease has any fiscal impact on the ratepayers?
Madam Speaker, as a matter of fact, I do not. I would note that unlike the regular commercial leases, perhaps which the legislature has entertained previously for the submerged lands for GTA, in this case, we have just put in for the lease terms a nominal amount of $100 per year for the 25-year term, so that it would have no impact on anyone as far as fiscally. And that was simply so that we could convey the property to Guam Power so that they could build a power plant on it, and at the end of the day then transfer it back to us. But we don't see any fiscal impact of any kind on that.
Is there any risk to the government of Guam in this leasing for $100 to the contractor?
No, Madam Speaker, we don't believe so. This is together with the ECA, the contract between GPA and KEPCO for building the plant. The lease rises and falls with the contract. If for some reason the contract is terminated because the contractor defaults in that, then the lease is terminated as well. And you notice also that there is a provision in it so that it's a 25-year term, but if there was reason for GPA to extend that an additional 5 years by agreement with KEPCO, the lease term would extend as well, but would only extend contingent upon a successful contract amendment being negotiated with KEPCO.
For the additional 5 years only?
Yes, and that is limited both by its terms to our enabling statute, which does not allow us to go past 30 years for long-term contracts with energy providers.
All right, so could you just remind us what the contract entails? We lease them the property for $100. They built the plant, and then they lease it back to us?
No, this is a build, operate, transfer. So they would build and operate it for 25 years.
They would operate it 25
yes,
years.
And then at the end of the 25-year term or 30-year term, as it could be, the power plant is returned to us. This is similar to the IPPs that we previously had with MEC, and before that for the Tangeesan property as well.
Okay.
So it comes back to us, and GPA owns it at the very end.
All right, but there's an operating energy conversion agreement, or is that what you call that, the operation
yes,
component?
Yes, that's the energy
agreement.
Yes.
Yeah, so we would pay them for operating it, correct?
And we do. And we also pay them a capital component, which addresses the cost of the plant as they go along. And so that's how we basically paid off the plant by the time the 25-year term is up.
All right. Oh, yes. Could you just clarify, is the lot description in the bill the same as in the attachments or the exhibits? Or you don't actually have to clarify that right now, but if you could, when you submit the amended exhibits, make sure of all of those types of legal requirements. Because our council has suggested to us, instead of reiterating the lot description in the exhibit, that we just say we are approving the attached exhibits and leave those descriptions intact. But I do see the benefit of putting the description of the lots in the bill so that when people are researching, looking for it later, they will be able to access it by lot number.
And that was the only reason, Madam Speaker, that we did put it in, so that it was
Okay.
clear to all the parties
Sure.
what lots.
So if you could just confirm for us, when you submit the amended exhibit, that is still the legally valid description of the property. All
And
right.
together with that, Madam Speaker, we have attached the recorded, I mean, maybe it's a little hard to read, unfortunately, but we did attach a copy of the recorded map as filed with Land Management, and so that would have the lot numbers, but we will confirm that both descriptions are correct, Madam Speaker.
Okay, and for those who are watching, so Section 3 of the bill says waiver of application of 21 GCA Section 60115. Would you just explain that briefly?
Yes, Madam Speaker, there were 3 waivers in there.
Yes.
I believe that is the requirement for the Municipal Planning Council, requirement that there would be an additional hearing. And I think specifically as to the PD lot, there was a very recent one in the last, 6 months, I believe, 6 months to a year. And so we had asked for a waiver of that requirement because they had previously been done to have another Municipal Planning Council meeting and,
All right.
and resolution.
And the other waiver, 5 GCA Section 5127.
Yes, Madam Speaker, that is the requirement for the exceptional term leases. Since we are certainly asking for a 25-year lease with a potential 5-year option, we're asking for a waiver of that
Okay,
requirement.
the waiver of the 5-year
Madam
restriction
Speaker.
for leases. All right, and
And
then
then
the,
2 GCA,
Yes.
2107 and Section 6.04C1, that is asking for requirement to waive the appraisals. In this particular case, we do not believe this is a normal commercial lease in which we would be seeking to see what market value is of the lease. I mean, I assure you it is clearly more than $100. I mean, these are 25-acre parcel for the Ukadu property, and a 5-acre parcel for the PD property is clearly more than $100 a year. But we're asking for that to be waived because our position would be is that if we were charging the commercial rent, it would just be passed on to us in the form of a higher cost. So we believe it's, once again, benefiting the ratepayers for a nominal lease payment.
all right, thank you. I'll now turn the mic over to Senator San Agustin, the author of the bill. No questions by the sponsor. Senator Taitigui? Senator Brown?
If Senator Addo doesn't mind, I'm sorry, I have to attend a graduation. I do want to ask a few points. I mean, I'm going to have to reconcile in my mind because I historically do not vote for any type of zone changes in the Guam legislature. That's kind of been a 28-year record that I've had. I only voted once, and that was to return a legislative zone change back in Agania Heights to a zone change that was made by the legislature. So I understand you'd relayed these properties that were transferred by PITI were unzoned, and in the case of the DEDEDO property, it's up to M2, but not zoned specifically for a power plant. Attorney Botha, I just want to clarify that.
Yes, Senator. The PD lot has no zoning because it was deeded to us from the Navy, and traditionally all of the Navy properties, regardless of how they're transferred, have no zoning. The Ukadu property, it is zoned M1, but I guess my point onto that is that there is no zone, either M1 or M2, that specifically includes a power plant under any of the permitted uses. And so that a power plant is a conditional use no matter where it's located, because there's nothing in the zoning code that provides for a power plant.
And then the point the speaker also brought up with regards to the, no argument on the use of the ultra-low sulfur diesel. But on the natural gas, I mean, that to me is another discussion for another day, because the infrastructure that's going to be required to install what you need to transport natural gas coming in from the port up to the facility, there's a lot more infrastructure and issues involved in that, including where you would site that location and what impact would it have to the surrounding community and what the safety zones would be, and a whole host of infrastructure, and how's that going to integrate with the operations of the port. Could you briefly explain that here?
That's correct, Senator Brown. We still have to, we did a study a few years ago, and however, that study we know has to be updated. And again, so we're going to go through the process again before we get towards natural gas. And again, even natural gas has to go through even our process, the CCU process, the PUC process. So it'd be a different vetting because all we're doing today, because we only have one crack at it, it's really like the machine could burn both diesel and natural gas. And the pipeline, so that we don't dig up things again, consists of two pipelines, for natural gas and diesel. The rest of the infrastructure has to be, again, additional infrastructure costs has to be vetted, approved by the CCU and PUC, and of course the community will have their input on that. But that will come another day. The base of this is the ultra-low sulfur diesel.
I appreciate that. It's only because when I was at the port, we certainly were involved with GPA with those discussions, and I know there's some conflicting issues because of the limits of the land area down in Cabras, where the location would be, what the safety zone would be, and how would that impact port operations that exist now. And I'm sure that's another day. It's a bigger issue. We certainly understand the importance of getting this northern plant constructed and the benefits that will be provided to the community. But again, it's just a word of caution because that's a bigger piece of the pie to I guess, digest. And it's just bringing those issues up because there's going to be a lot of work that's going to have to go in that and have some comfort level for the community there. And then also just the land area and the safety zone that's going to be needed to accommodate that so that it doesn't adversely impact operations there at the port. I wanted to ask for the clarification with regards to arbitration. Is that the venue, again, only because I've had history with arbitration, and granted this is not the same type of contract or lease, but for the port, the arbitration clause that was added was a disaster for us, including the outcome that the only thing that allowed us to go back to the Supreme Court of Guam is because we challenged the validity of the contract itself. Because there's restrictions that are put in place as to how you can challenge a decision made during arbitration. So I'm not exactly a big fan of arbitration as a means for resolving issues. Maybe for some it works out. My experience, it was a very cumbersome, very expensive, and the outcome of the arbitration panel had me wondering if I should go get a law degree. I just was not impressed. So I want to find out what does this mean for the Guam Power Authority, because I'm not a big fan so far of arbitration because of the experience and the costs and the hassle that we went through. So I don't want to see that for GPA. So does this limit the Guam Power Authority from pursuing cases in court if it doesn't agree with the arbitration panel? Because there's very restrictive language for those that are big fans of arbitration and that provide this type of service. They think this is just the greatest thing since sliced bread. But if you don't come out with a judgment that's in your favor and you don't agree with it, you can be stuck with it. And I don't want the ratepayers of Guam to be stuck with it if it's not a decision in their best interest. So can you give me some feedback on that?
Yes, I think, Senator Brown, we also discussed this with the Attorney General's office, who is equally not quite a fan of arbitration in general. We did explain for this particular lease, the arbitration was one of the things that the lenders insisted on in this case, because they are loaning approximately $750 million on this project, and they wanted to ensure that they had a more neutral place to go should there be any issues with that. I would note that we have had arbitration in our previous ECAs and IPPs, and we've never had a reason to address that. I mean, we've never gone to arbitration in any of those issues before. It just seems, in this case, the lenders, wanted the opportunity to have something else that they felt would give us less of a home court advantage. I mean, if you will, being Guam Power Authority and having access to the courts here. We looked at the issues with that, and we think with the ECA that really it's going to come down to, whether the operator is performing correctly, in which case that, we're going to have the ability to, ask the lenders, since basically it's, they're giving sort of as a performance bond, if you will. I mean, we have the benefit of the performance bond that will exist for the length of the contract, so should they not be following that, we would be able to invoke the performance bond should there be deficiencies in the operation, or if it's, you know, if obviously if the contractor is not paying their lenders, then the lenders can step in and put in a new contractor, which we'd have the right to approve in any manner. So it basically came down to the efforts of the lenders' requirement that they wanted to make sure they had some type of arbitration in here. You know, obviously there's
Yes,
first
but I'm
mediation.
assuming that if this arbitration is in here, I mean, whose laws are going to govern where would this arbitration take place? If it's on Guam, there
No,
are a
no,
lot
the
of
laws,
restrictions
the laws
that
of
come
Guam
with this.
govern that.
Where would this arbitration take place then?
So it would take, and that's why there is the reference to the other provision that calls for the courts of Guam to be, you know, the ones that are determining that, just so that it could either be either the Superior Court or the District Court of Guam that would, you know, take care of any arbitration issues.
But the parties would be bound by the decisions of the arbitrators.
That's
Short
correct.
of any illegal activity or suspicion to that, you're stuck with it. That's why I'm asking, because, I mean, I can understand your lenders wanting to protect their interests, but they don't want these issues decided in the Guam court system. But ultimately, it's the ratepayers of Guam that are going to be paying the loans back and paying ultimately for this power plant. So I don't know. I have to tell you, this puts a big question mark in my mind personally. Might just be me as a member of the legislature. Otherwise, I'm very supportive of Guam Power Authority. But again, just because I've actually had to go in the trenches with this issue, hopefully GPA doesn't encounter similar issues. But I have reservation as a result of it, because I've seen the ugly side of arbitration, and I've seen how people have tried to use and abuse it to their advantage. And I don't care for it personally to be included in these type of agreements, nor would I want to see it in future agreements for Governor Guam contracts. So I don't know that you can necessarily give me some comfort level because of just what I've experienced in dealing with the arbitrators and the court system on Guam with this, that I have reservations. So I'm just going to note that. I may or may not vote for this bill as a result of it. It doesn't reflect on the need to construct this facility. Otherwise, John, as you know, I'm very supportive of the desire to get this power plant constructed, but I am concerned when I see things like this put in an agreement. I'm sure the lenders want to protect their interests, but I also want to make sure that the interests of our ratepayers are protected, and I just have reservations with regards to arbitration, having seen it implemented here. So thank you, Senator Tello and Madam Chair, for the opportunity to ask these
Thank you,
questions.
Senator Brown. Now, I want to be clear on the record. So there is an ECA, which is another document that we are not approving here, and that is, the ECA is the Energy Conversion Agreement with Project Company. That is like the operating agreement, I think. The construction and operation agreement. And and then we are approving here leases of the land. But this, in the lease, it says any dispute is going to be resolved under this lease agreement. A dispute under this lease agreement will be resolved either by the Joint Coordinating Committee pursuant to the ECA, or mediation upon mutual agreement of the parties to go to mediation, or arbitration. And then it's very specific that this arbitration is pursuant to the rules of arbitration of the American Arbitration Association. These are the AAA arbitration rules. And that the arbitration shall take place in Los Angeles, California, and that, yeah, so that's specific, and those are in the lease, pages 14 and 15. So if you don't mind, that issue's been raised. If you want to submit additional testimony in that regard specifically, that would be welcome as well. Thank you, Senator Brown. Senator Taitigui.
And thank you, Madam Chair. Good afternoon, gentlemen. Thank you so much for being here this afternoon and providing your testimony. You know, I was just wondering, you know, we're trying to have session, you know, if we can, either the end of the month or the beginning of next month. I'm pretty sure this is priority, you know, because it's needed right away. My question is the issue with KEPCO, you know, wanting these changes, you know, to the agreement. How long ago did they bring this to your attention?
The changes to the agreement, Senator, were brought up as far as the actual lease agreement itself was brought up in November of 2021 by the lenders. And then KEPCO has been working for the last 6 months to get a recorded parceling map, which is a requirement for the legislature to approve any lease. And then the additional one-page changes that were brought up today, we had submitted those, a copy of the lease agreement and the draft bill to both the Governor's Council and the Attorney General's office, and so they only very recently gave us their comments on that. So that was just last week.
Okay. This bill was introduced on April 29th, and I know that you're asking for a waiver with regards to section 60115 that the speaker was talking about earlier on the municipal council. And, if you guys had the time to do it, I just didn't see why there would be, bypassing the involvement of the community, especially in these areas. I understand now, of course, there's a time issue here. And, but, I appreciate all the other public hearings that you mentioned earlier that you were having. But can you tell me, John, in some of those public hearings, did they bring up this particular circumstances? Because I know when you were talking about the power plant and the generator in PITI, and this is the same area. Did you talk to them about that?
I think this is a requirement by the lenders, Senator Terlaje. And again, before the bill could be submitted, they need to record, do the surveys and the recording and approval by land management. And so even themselves, of course, they in their busy state, we really had to work real hard to get it done as quickly as possible. And so these are the last condition, really, before the release of the majority of the financing, which is over. What's left to be released is close to 600 million. Then that will now just pull the power plant full bore. But again, this is the lenders that insisted on this to be done. And again, it couldn't be recorded. It couldn't be introduced by us without the lot numbers, the exact description and all of that, which only just came I think about a week before it was introduced.
Yeah, April 29th. Okay. Is there a time? What is the time constraints on this piece of legislation?
Yesterday, yesterday, Senator.
Yesterday?
Yesterday. And
yesterday.
The reason for that is really we want them to release the funding because, again, it will start the ball moving. There are contractors that are on hold, and again, it's costing money, could increase their costs. So we want to do our part, and that's why we're working, and we've been working real hard with Senator Agustin to get this on the table as soon as possible.
Okay.
And again, couldn't do it until we get the lot numbers and everything.
Okay, thank you, John. Yeah, we talked earlier about this is section 5 of the bill, which is talking about the waiver for 217. And it says, it talks about the appraisal requirements are waived for the lease of the properties, but my question is, will any trade for services require GBA to follow procurement laws or require legislative concurrence?
Not for this particular provision of that, Senator. This was just one for any commercial lease that, to make sure that it's at market value, as there's been I believe some concerns in the legislature that prior leases and arrangements that have been out have been far less than market value. So I don't believe that a waiver of that would impact us in any form as far as an appraisal requirement.
Appraisal, yeah, but what about procurement?
Not as far as procurement. I mean, the lease only applies with the energy conversion agreement. It's part of it, right? It's just that they have the legal ability to be on the property for the 25-year term, and that they can hold it as a leasehold. Lenders can hold it as a leasehold mortgage for that purpose.
Okay, thank you for that. Many of the questions I had were answered, and I appreciate your time being down here, and thank you again, Madam Chair, for the opportunity.
Thank you, Senator.
Thank you, Senator Teitzke. Senator Ada. Oh, all right. I have one further question. That is on the, so we've seen with the power plants down in PITI when, I don't know, something happened, the insurance, I don't know, there was long dispute as to whether the insurance covers those incidences. Do you believe there's adequate insurance in this lease for these properties to protect the interests of the people of Guam?
The insurer of this will be by KEPCO to ensure that they protect the interests, and of course even the lenders, no? Just like we're required to have insurance for our bonds, for anything we borrow. Of course, KEPCO will have to satisfy the lenders' requirement that they may be made whole in case anything happens. No? Correct me if I'm wrong, Ryan.
Well, the lenders will be made whole, but what about our interests?
Madam Speaker, we're always listed as an additional insured on those policies, so that if there was any environmental issues or whatever, that GPA is also an additional insured under that policy. Should there be any environmental issues or anything else like that?
All right. What about? Will there be enough? For example, I think that was the issue down there. The recovery funds were not enough to fund a replacement facility by far, right? Or anything like that.
I believe the $125 million that we got.
Sorry.
I believe the $125 million that we received insurance proceeds was more than adequate to replace Cabras 3 and 4. Obviously, we determined that it would be much more efficient to bring on a new unit in a different location. But I certainly believe our funds, that was through Lloyd's of London, and I think those proceeds were more than adequate for the replacement cost of those units.
Okay, so you believe that that type of arrangement is in this agreement as well?
Yes.
All right, thank you. Senator, there are no other questions, so Senator Agustin, you can either question or close on the bill.
Thank you, Madam Speaker. I just wanted to make, when my colleague asked the question of how soon ago was it when you knew about when we introduced the bill, I just want to make it clear that I was working with GPA just a little bit before we introduced it, and it was to make sure we got all the maps. We wanted to bring everything, we want to make sure all the I's are dotted, the T's are crossed, and then we worked with all the attorneys and yourself to make sure that it was as clean as possible bill, and that it hopefully would get by and it worked. And I believe the bill has met its requirements. And I'd like to thank the chair, Madam Speaker, for hearing the bill, and to my colleagues for their participation and encouragement in working to bring clarity to the bill and making it stronger. We have another opportunity to help GPA from violating the consent decree, but more importantly, helping to bring reliable power to our people. Thank you to the working people at the authority who are committed to keeping rates as low as possible while addressing all other issues that come with power generation. Thank you again, Madam Chair, Madam Speaker. I appreciate you working and hearing this bill and also reaching out to our stakeholders for their input. I look forward to deliberating on this bill in session so we can move forward with bringing cleaner and more reliable power to our residents. Sizus Masi.
Sizus Masi. Thank you very much.
Sizus Masi, I also want to state, so the bill was introduced and then it was referred on April 29th. Just a second. Yeah, so it was referred to our committee on April 29th, and we tried our hardest, as we had said we would, to set a hearing date as soon as possible after that April 29th, and we did. That was, we have very few hearing dates, so the chair of the Committee on Appropriations actually allowed us some of his time on today's reservation to have this hearing so that we could have it timely. So if you could just describe the time sensitivity of this bill.
There were two conditions that needed to release the funding, and then which will allow notice, the full notice to proceed and move forward quickly in the construction to meet the April 2024 deadline. The longer it takes, then that April 2024 deadline will start to shift, or at least they're going to continue to try to shift it with me. No? So if we get this satisfied, we basically have satisfied all their conditions, and they have no reason more to hold us back in getting the job done. No? Senator, so the other condition is the draft permit on the US EPA, and that's coming any time now. So those two conditions, I can maybe at that point sit back and watch them and crack the whip and say, get it going and get it done, you know. But right now, this is the last two, right, Graham? No more lawyer.
We trust that there'll be no more additional conditions with that, but those are the two conditions from the lenders, the draft air permit and then the legislative lease approval. We obviously were working with Senator San Agustin before this. We had gotten the one lot approved approximately a month before, and we were originally thinking if we could have one with just the one lot number on it, but we thought that it would be best to make sure that we have all of the recorded lot numbers in case land management changed something. And so that was why there was the delay in submitting the recorded parsing maps, unfortunately. I mean, it's not that we haven't owned both properties. I mean, the PITI lot we've owned since the 70s, since we got it from the Department of Navy, but the parsing map was necessary, just to carve out that particular area, the 5 acres and the 25 acres that KEPCO and Guam Power was entitled to. So that was the basis, fortunately, for the delay with land management.
All right, thank you very much. Again, Mr. Benventi, it's always a pleasure, and thank you so much for your testimony today, Attorney Botha, Attorney Haraki. So there being no additional individuals to present further testimony, this committee will consider Bill 301-36LS duly heard. The public hearing is now adjourned, and the time is 5:10 p.m. Si Diyos masi.